Hello, welcome to the Cannaployment Smoke the Competition, Not the Rules, Avoid High-Cost Employment Compliance Mistakes Common to New Cannabis Companies webcast. Welcome to our webinar. We have a great discussion today. We have some wonderful guests on this webinar who are truly pros when it comes to compliance and hope to help you with your cannabis business. My name is Jim Ickes. I'm an attorney at the law firm Zuber Lawler. Zuber Lawler is a global company with a traditional base of Fortune companies, yet they remain clear-sighted futurists who excel in emerging industries and technologies such as cannabis, psychedelics, clean tech, cryptocurrency, and artificial intelligence, just to name a few. Okay, we're also glad to have representatives from Greenleaf-HR and FlowerHire here today. Now a disclaimer. The opinions expressed are of the individuals and not any companies associated with this presentation. We don't encourage the use of illegal drugs. Consult your healthcare provider and attorney regarding the use of cannabis. Nothing in this presentation creates an attorney or fiduciary relationship. Please seek the advice of your own professionals. All right, so let's get down to it. First, I'm going to allow our panelists to introduce themselves today. I'll go to you first, Beatrice Runyan. If you please tell a little bit about yourself and your company.
Sure, thank you, Jim. Hi, my name is Beatrice Runyan. I'm the Associate Vice President of HR Compliance for Greenleaf-HR, and we are a leading cannabis human resource management company, and we're headquartered in Central California. And our company provides customizable back office administrative solutions for both small to medium-sized organizations. And we also help to serve the human resource management needs for a variety of cannabis-based companies all across the country. We handle everything from payroll, HR support, benefits, and risk management so that your organization can focus on what's important and your actual work.
Okay, fantastic. I'm going to go down to Jason Desentz. Jason, if you could please tell our audience a little bit about yourself and your company.
Yeah, hi everyone. Thanks, Jim. Appreciate it. My name is Jason Desentz, and I am a managing partner at FlowerHire. FlowerHire, if you're not familiar, is the #1 cannabis recruitment agency and HR advisory service. We work with all marquee folks across, whether you're a single state operator, multi-state, but we work in every state that's currently and about to go into cannabis as it relates. So on the advisory side, we do everything from reorgs, compensation planning, which has been a big one lately, or if you're looking for an HR audit just to see where you stand as you continue to grow. We like to work with startups, but also we like to work with the MSOs as well. Thank you.
Now I'm going to go over to my colleague at Zuber Lawler, Raza Lawrence. Raza, if you could please tell a bit about your practice.
Hey everyone, my name is Raza Lawrence. Great to be here and to see you all here. I'm at Zuber Lawler's Los Angeles office, our headquarters. I originally grew up in the Midwest. I've been practicing cannabis law since 2009, and I've also done a lot of employment litigation investigations and advising, both with respect to individual and class actions. And I've seen the types of liability that can really pile up with bad policies. So hopefully everyone can learn from today's presentation and try to put their business on better footing liability-wise. The cannabis practice that I've been involved in has shifted a lot over the years. Originally, I was representing medical marijuana collective and cooperative members in state and federal courts. Did a lot of felony criminal cases, jury trials, focus on keeping people out of jail and prison, avoid having their assets seized. And once licensing started, I've helped a lot of people who were involved in the previous collective industry transition over to the new licensed, heavily regulated industry and adjust to this new legal landscape. Now we're in a kind of difficult economy, and especially in this industry, and been helping a lot of businesses navigate disputes, enter into IP licensing agreements, joint ventures, different types of financing and acquisitions, finding different ways to succeed in this challenging economy. I found this really to be a fascinating industry to work in, especially because of the conflict of laws, the quickly changing laws, and kind of adapting to these shifting legal landscapes. And I've also found that a lot of people who have been involved in the cannabis industry for a while have found it to be kind of a culture shock, adjusting to this new regulatory landscape. heavily regulated. People were used to doing kind of handshake deals, operating in secrecy, keeping few records. Everything was in cash, trying to evade law enforcement. And now they have to comply with a long list of detailed laws and regulations, and they have the whole sort of court system and open to them that was largely closed before during Prohibition. So I'm excited to be here today. Thanks everyone for joining.
Raza is very, very smart. So I get to hear him in practice group meetings talk about various issues, and so I'm excited to hear his comments today. So, but last but not least, we're going to go to Greg Cowan.
Good morning, everyone, and thank you, Jim. My name is Greg Cowan, and I'm a business consultant with Greenleaf-HR.
Fantastic. Well, let's get right to it. First question, let's kick it off with Jason and then Beatrice, okay? What are the most common employment compliance challenges that new cannabis companies face? So let's get right to it. Kind of a big question to set the stage here.
Yeah, I think a lot of it really stems from that transition that Raza was talking about, the illicit market now going into the professional market and actually having to understand all the regulatory things that they didn't have to worry about prior, like, classification of employees, making sure that they're either exempt or non-exempt. A lot of what we've seen, and actually through the HR audits of recent, is that companies are misclassifying a lot of their employees, and that could be a big, big problem for them. More importantly, not only do you have to pay a fine, but you have to pay back pay, and that's related if you have someone listed as an hourly versus a salaried employee or exempt, non-exempt, and you owe them back pay for overtime they work. And the challenges can be anywhere up to even losing your license, per se. So a lot of these that we've seen in the industry, it's really that first transition to the professional world. And then also folks like that have come outside. I was originally 20 years in automotive and was a CHRO at a publicly traded company. Cannabis is different. All other industries are highly regulated. However, cannabis, you'll start to use your own resources and find out they're not in cannabis because it's illegal in the United States. So a lot of your resources are actually trimmed down that you can use as a business professional. However, that's changing in the landscape really day by day, quite honestly.
Fantastic, thanks. Beatrice, you're on mute.
We just talked about that and I did it. Sorry. Fail.
All right, a little levity. That's good.
There we go. That's right. One of the other things you want to also look at is just navigating all the different federal and state regulations regarding, the cannabis use. And a lot of times there's conflicts between the two, federal and state. There's some conflicts there. IRS regulations, as Jason mentioned, misclassification. Another big thing to be concerned about is the wage and hour laws. In some states, specifically California comes to mind, the meal and rest breaks are very, very strict. So just being cognizant of those rules and making sure that companies are staying compliant with all of those types of regulations, background checks, which I know we'll talk about lately as well. Those are just some other key compliance things you need to be concerned about.
Absolutely. Thank you, Beatrice. A question for you, Raza. Can you provide an overview of the specific labor laws and regulations that apply to the cannabis industry?
Sure. There's federal, state, and local laws that all might come into play, and sometimes they conflict with each other. Sometimes more provide more protection than others. Basically, under the supremacy clause to the U.S. Constitution, federal law supersedes or trumps state law if there is a conflict. But state laws and local laws, cities or counties, they can also provide greater protections than federal law allows for. So I think to start out with, you want to look at federal laws because those apply to everybody, wherever you are. And some federal laws apply to all cannabis businesses, no matter what the size are. One of those is the Fair Labor Standards Act that creates the right to a federal minimum wage. It's only $7.25. It's a lot higher in many states, but that's where the minimum wage came from. Also, the time and a half overtime pay comes from federal law for over 40 hours per week. The Federal Fair Labor Standards Act also prohibits employment of minors in oppressive child labor. Most of the cannabis industry does restrict employment of minors to start out with, so that might not be an issue. Also, the federal law that applies to everyone, the Equal Pay Act, it was an amendment of the Fair Labor Standards Act by JFK, and it was aimed at abolishing wage disparity based on sex. We've got the Federal Immigration Reform and Control Act that applies to everyone. It makes it illegal to hire undocumented immigrants. And it sets in place financial and other penalties for companies that employed undocumented immigrants. We'll get into a little bit later. There's the immigration issue in general in the cannabis industry, and that if you're not a citizen, being involved in commercial cannabis can cause you to get deported or denied a green card or asylum. So, unfortunately, immigrants are, it's risky for them to be involved, period, in this industry. Also, the federal law that applies to everyone is called ERISA, Employment Retirement Income Security Act. It sets minimum standards for most voluntary pension plans, retirement and health plans to provide protection for individuals, and sets forth certain federal income tax rules. Now, there's another category of federal laws that apply. They kick in only after you hit a certain number of employees. So depending on how large your business, these may or may not apply. There's the Family and Medical Leave Act that kicks in with 50 employees, and it requires employers to provide eligible employees with unpaid job protected leave for specific family and medical reasons. We've got the Americans with Disabilities Act, the ADA, that kicks in with generally with 15 employees. It prohibits employers from discriminating against employees with disabilities and employment practices such as recruitment, compensation, hiring and firing, job assignments, training, leave, and benefits. And then you've got COBRA, it's called, kicks in with 20 employees, and it requires employers that offer group health plans to offer continuation of coverage for eligible employees and their dependents when employment's terminated. Finally, federal law called EEO-1 reporting. It only kicks in once you have 100 employees, and it requires employers to submit employment data categorized by race and ethnicity, gender and job category to the EEOC, so they can keep tabs on whether there's discrimination going on.
Wow, the long list.
And sure. I think that there's the next topic then is the state laws and how those might differ from these kind of baseline federal law that everyone's dealing with. And there's a few topics that you'll want to keep in mind. If you just only follow the federal laws, you're going to be in trouble, especially in some places like California that tend to have more additional and more expansive worker rights. And you can face a huge amount of liability if you're not focused on those state laws. So first of all, wage and hour laws. Mentioned before, a lot of states have higher minimum wages than federal law. California, I believe, is $15.50 an hour, over double the federal minimum wage. And many cities also have their own local minimum wages law that can be even higher than state law. Also, meal and rest breaks were mentioned before. In California, employers have to provide unpaid meal breaks and paid rest breaks. Federal law generally doesn't require this. If you don't provide for these, the liability can stack up really fast. There's rules about reimbursing employees for business expenses. In California, employers have to do it, while federal law allows an employer to refuse to pay business expenses as long as the workers are earning a minimum wage after you factor in any reimbursement. Overtime laws. State laws can provide more circumstances where overtime is required. For example, California non-exempt employees are entitled to overtime pay, which is 1.5 times the regular rate of pay for any hours worked over 8 in a single work day, and also 40 in a work week. Federal law only kicks in when it's over 40 in a work week. Also under California law, any work beyond 12 hours in a workday is subject to double the regular rate of pay. Sick days, vacation days, those can differ between federal and state law. In California, workers are guaranteed a certain number of sick days, and vacation days they earn can be cashed out at the end of their employment. Federal law doesn't tend to have this, so keep that in mind in connection with any terminations of employment. The next category that can differ a lot is discrimination and harassment laws. Federal law prohibits discrimination based on certain categories: race, color, national origin, sex, pregnancy, religion, and age. Age only if it's over 40 years old, and disability. State laws often have additional categories that are protected from discrimination. In California, the Fair Employment and Housing Act includes additional protected categories such as marital status, sexual orientation, gender identity and expression, AIDS, HIV status, medical condition, and military or veteran status. California, interestingly enough, also prohibits employment discrimination based on political affiliation or activities. So in California, you're not allowed to promote employees or fire them based on whether they're Trump supporters or Biden supporters, whatever your preference. You have to treat people equally, regardless of their political views. State laws also sometimes require sexual harassment prevention training. In California, any employers with 5 or more employees has to provide this to everyone. It's generally not a requirement under federal law, but some states have that. Family and medical leave is another category. Federal law provides up to 12 weeks of unpaid leave for eligible employees in certain circumstances: birth of a child, adoption, foster care placement, care for a spouse, child, or parent with a serious health condition, or for an employee's serious health condition, and emergencies involving family members on military duty. State law can provide additional protection. California's Family Rights Act provides for 12 additional weeks, so you can have up to 6 months of leave, although it's unpaid. But generally, for these leave laws, when an employee is out for one of these covered reasons, their benefits have to keep going while they're out, health insurance and so forth, and they have to be offered the same or equivalent position with the same benefits, pay, and terms of employment once they come back from the leave. Worker classification, that's another area where you want to make sure you're doing things right, and specifically employees versus independent contractors. This has become an issue with Lyft and Uber and gig economy jobs like this, whether they're employees or independent contractors. There's a test generally that applies in California. You have to look at whether the worker is free from the employer's control and direction, whether the worker performs work outside the usual course of the employer's business, and whether the worker is customarily engaged in an independently established trade, occupation, or business. California's test is a little stricter. Other states are a little bit more looser, but if you don't follow these and you just call people independent contractors when they're really employees, you can be subject to hefty penalties under state laws. At-will employment exceptions is another category. When can you fire people? Most states, including California, it's generally at-will employment, meaning you can fire someone for any reason or no reason at all, so long as it's not discrimination or some kind of illegal reason, such as if they complained about discrimination or harassment. But generally, California and other state laws prohibit retaliation for various reasons, including filing a workers' compensation claim, discussing wages, or engaging in political activities or speech. So that's kind of the lay of the landscape. Each of these topics could go into in a lot more detail.
Yeah, we could go on for another couple of hours. We haven't even gotten to the cannabis laws and regulations. So I think that, and also municipal law and a whole nother layer of it on companies. So I want to go back. I think that kind of sets the stage, and you see this absolute abyss of laws. I'm going to go back to you, Jason, and Beatrice, and ask if you could please discuss the specific regulations surrounding employee training and education in the cannabis industry, specifically, since I know you guys are in the weeds on this.
Pun intended, I guess.
Yeah, for sure.
Go ahead, Beatrice.
Yeah, no, I was just going to kick off. So some of the things, there's a lot of specific regulations that talk about employee training and education in the cannabis industry, but it also can vary depending on your jurisdiction. So you need to be mindful of that. But a lot of the common requirements are, training on not just the cannabis laws and regulations,
right,
but safety protocols, proper handling and storage of the cannabis products, how to, if you're in the retail side of it, the identification and prevention of underage sales, proper record keeping, adhering to good manufacturing practices. There may also be mandated specialized training for specific roles such as bud tenders or medical cannabis consultants. So, it's important to stay up to date on the different regulations, not just, just by jurisdiction may vary. So Jason, if you want to add to that.
Yeah, I just want to start off by saying what Raza said. Don't worry, it sounds worse. You're going to be okay.
Yeah,
Because
that's right.
when you hear all of that, to me, I might not want to open up a business. But really, what it is just just be smart, right? As you think about a business, make sure you're educated as a business owner and your leaders are educated. But more importantly, that then leads into your folks on in the front lines, right? Making sure that they have all the resources available. But you're right, there's a lot of the regulatory stuff outside of cannabis that I would also make sure and recommend every year people have a mandatory training, and it can be very simple. It doesn't have to be complex. And a lot of systems, like I know that the folks here on offer, as well as the different course categories like sexual harassment, diversity training. But as you get into cannabis stuff, there's things like pesticides, depending upon what they actually use in the creation of the cannabis. It's making sure that health and safety of your employees is number one. And I know that we use pesticides in some cases, and that's important that you give all the proper training for your folks, and also have the proper equipment, right? And teaching them how to wear the equipment, because some are outdoors grows, some are indoor grows, and the indoor grows,
Right.
if you've never seen them, are crazy awesome. I mean, I've seen electrical back in manufacturing days, less, I guess, gowned up as you have to go in some of the cannabis ones. So it's really intriguing to me. But they train a lot of those folks, making sure they put booties on, hair nets, making sure that the the mites or the spider mites don't get in and destroy an entire crop. So it's really dependent upon how are you going to operate your company, and then make sure you back into the training with that. And specifically around cannabis training itself, there are other folks out there that are starting to come up. Green Flower being one of them. I know they work really well as far as teaching all the cannabis folks about bud tending, about terpenes, making sure that they can then provide the right information to their patients when they come in.
Yeah, fantastic.
And related to the training, I just wanted to point out the importance of having some kind of written policies, an employment handbook or policy manual. You can look for one used by others in your same state. You don't need to reinvent the wheel. But the idea is, if you have these policies in writing, if there's any problem down the road, any lawsuit, any complaint that's filed, you can point to the handbook and policies and say, see, we had a policy. If it wasn't followed here, it was this particular manager who maybe went rogue, but overall we have policies in place, so we shouldn't be liable. And then connected with the handbook, it's important to have documented training for managers, employees when they come on board, walk them through the policies. All of this is with the goal to show, in the event there is litigation down the road or a complaint, to show that you took reasonable steps for compliance. No one's perfect, but if you have these systems in place, you're going to be better off if there's a problem. That also goes for harassment and discrimination. As I mentioned, some states require the training, but even if it's not required, it's certainly valuable if an employee makes a claim of harassment or discrimination, to show that you have these training policies in place. It reduces the odds that you're going to get hit with a big judgment. And also just having a lawyer involved when you're putting in those policies to sign off, that can look good too, just to show that you've consulted with legal counsel and you're making reasonable steps to do things the right way. So if you have these different protections in place, it tends to protect you from systemic or policy problems. Those are the types of issues that can create really large liability, potential class actions, or multiple employees, all claiming the same things. But these are all tools to minimize the big hits that can come from employment litigation.
Yeah, and to your point, Raza, and to Jason's point previously, that is something where any of the organizations, any of the panelists that are on here, our companies can aid with, helping create the handbook, and then having an attorney review. We always recommend, even if you have an organization create the handbook for you, always have your labor attorney review that for you. So, our organizations will be more than happy to connect and work for that for you.
I try to keep it pretty simple for my clients, and I tell them, you got to make it look to the regulators that you give a darn, that you care about it, that you spend some time on it, and you spend some time with your people on it, and they can tell that you cared about it, which is, I think, a good way to look at it. So I think the next, Raza, your statement, and you too, Beatrice, I think it leads into, it's a good segue to the next question. how can a new cannabis company ensure that its HR policies and practices are aligned with local and state cannabis laws?
I think the first thing is knowing what those are. Doing the
Yeah.
research to really understand what the specific laws and regulations that govern wherever your company's jurisdiction is, both local, state levels. And then again, consulting with legal professionals, consider, and then reviewing the policies on an ongoing basis, because policies change.
Right.
I would say this for any industry. You can't just do a handbook and then put it on a shelf and forget about it and let it gather dust for the next 5 years. You should be reviewing
That's
that
right.
on a yearly basis, ideally, if not more frequently, but definitely on a yearly basis. There's several other things. I don't know, Jason, if you have anything else to add to that.
I would always say document too, right? Document,
right,
document, document, right? Every lawyer likes to hear when an HR person says that, but it's true, because you want to document when people take the training, you want to document when things occur, where it goes against the training. And then to Beatrice's point, every year your HR team or whomever should be re-looking at all your policies and procedures, because guess what happens every year? Laws change, laws update, and you need to make sure you get those updates in there. But if they're not, again, everyone on this panel can probably help you out with that. But that's important that you self-reflect on your year. And remember, when you think of employee engagement, there's top 3 reasons why employees typically are disengaged. Sometimes it's comp, which I always know it's in there, but leadership, communication, and career development, which usually leads into training.
Right.
So making sure that your folks have the tools, which would be the enablement on those engagement indices, and making sure that you as HR or whomever are documenting it.
Well, I think next question. Thank you, Jason. I appreciate that. I think that was very thorough. Greg, I feel like we're leaving you all alone up there.
I'm on an island here.
I'm going to get you involved right now, though. So what are some of the best practices for conducting background checks on employees in the cannabis industry?
That's a great question. So we all know that to work in the cannabis industry, you have to perform a background check on every single employee. But it's incumbent upon employers to understand the worksite state's licensing requirement for background checks. And this is incredibly important for multi-state operators and folks who have remote employees, because each state is different, with some states allowing licensees to perform the checks with a third party, while others require a state-sponsored program and a live scan as well. If a third party is permissible, licensees who manage back office administrative duties through an integrated HRS can streamline that entire background check process in conjunction with recruiting and onboarding workflow to save a lot of time there. For example, my company, Greenleaf-HR's technology platform, allows licensees to customize that background check according to the state requirements and perhaps a job description. So for example, a delivery driver will require an MVR in addition to the requisite levels of support from either a county, state, or state, federal, or whatever the requirement is. But a bud tender will likely require just the base level background check. So it's important for employers to understand those complexities.
Different states can have different requirements on the background checks. For example, California, only owners 20% or above in the business, or managers who are the people in charge of the day-to-day operations have to pass the background checks. There could be local laws that require more extensive checks, but you want to look at the state and local licensing laws. Usually it's in the licensing laws or regulations that lay out who needs to get the background checks, what types of convictions are disqualifying, but make sure you're following that as required. But in addition to the legally required background checks, as an employer, you probably want to do your own due diligence above and beyond that. Even if not required by law, you want to look out for theft or fraud types of convictions, backgrounds. A kind of sticky issue is a lot of people in this industry, they will have criminal convictions from the past, dating back to the Prohibition era, and you have to use your judgment regarding what's acceptable with that. A lot of people realize that a lot of lives were kind of ruined by the criminal system, the war on drugs, and a lot of social equity programs these days in the cannabis industry are designed to provide sort of reparations for people and provide special benefits to people who suffered under the past criminal system. But it's important to be able to sort out, what types of criminal convictions are acceptable to you and which are red flags. And I would the red flags, tend to focus on the fraud and that type of thing.
Yeah.
Also a recurring problem in this industry is people with cannabis licenses are engaging in unlicensed activity out the back door or on the side. There's employees who might be, not following the laws and doing their own unlicensed sales on the side that can really jeopardize the whole business. So you want to make sure that the employees that are coming in are willing to actually follow the laws and not be doing their own thing on the side that can put the whole company at risk.
No doubt. And I think obviously getting into background checks, but the flip side of that is employee privacy. So I think next is a great question for whomever wants to jump in. What strategies can be employed to ensure a safe and compliant workplace while also respecting employee privacy in the cannabis sector? So you want to jump on that one, Jason?
Yeah, that's always a fun one, right? Because, privacy is sometimes dependent on who's defining it, right? So,
Right.
and especially in the cannabis space, I think we all would agree that we want honest people working at our workforce. But at the same time, when we have to use or conduct an investigation per se for a violation of a compliance policy, I think it's truly important, extremely important for leaders in the organization to, make sure they document, but also make sure they keep it confidential. And even when you have investigations and where you have discussions with people, when you're interviewing them to get their side, it's important that you also then remind the employee themselves that this is a confidential investigation, and make sure that you don't put anything outside, because what happens is retaliation, right? And people, or perceived retaliation that people have when they go back in an action or something, don't get a promotion because they complained or what have you. So it's really important that when you respect people's privacy, it's really more around making sure that they understand the business acumen side of it and why you have to do things a certain way, but it really protects not just you, the manager, the individual, and the organization.
Fantastic.
And regarding privacy, there are obviously a lot of medical marijuana patients in the industry, people who use cannabis for medical purposes. And I think the goal isn't to discriminate against cannabis use, but to prevent impairment from all substances, whether it be alcohol, cannabis, prescription drugs, and to have written policies in place that deal with that. Most state laws.
I think you've already headed into answering my question, Raza. If you go ahead and talk about how you can have policies in place to ensure a safe workplace.
Yeah, so this is the type of thing where if there's some kind of accident, especially if you're looking at delivery drivers, distribution drivers, or people operating, equipment, manufacturing, can sometimes involve, volatile substances, but you want to make sure you have policies in place so if there is an accident, you don't face liability for not taking reasonable steps to prevent this type of workplace impairment. Most states, maybe all states that allow licensed cannabis, they prohibit the consumption of cannabis on the work site. An issue with cannabis, though, is people who use it regularly, either medically or recreationally, it's going to show up in their system on urine tests for a lot of times a month or so after they used it. So there's not really a reliable indicator of how impaired someone is, like there is for alcohol, where there's a blood alcohol level and you can just it directly tracks the level of impairment. With cannabis, also regular users, they're going to develop a tolerance, where people who use it every day or several times a day, they're essentially going to be acting normal, whereas someone who has a lower tolerance could be totally out of it and not in control of their faculties. So it's important to have policies in place, preventing impairment on the work site, to pay particular focus to those types of high risk jobs, like drivers and people operating dangerous machinery. And in appropriate cases, it may be appropriate to do a drug test if there's an accident or some type of erratic behavior. But if you have these policies in place and you're not tolerating kind of open cannabis use by everyone on the job, you can point to these policies to protect you in case there's any problem. The one other issue that's worth noting, in California, starting next month, it's going to be illegal for employers to discriminate against people based on their use of cannabis when they're not working and away from the work site. There have been cases, usually it's not the cannabis industry that will do this, but other types of industries that they'll fire people for using cannabis even off-site. But now it's becoming more, there's less stigma associated with it, and more states are allowing it. The laws are starting to catch up and realize that people shouldn't be discriminated against just because they happen to use cannabis in their free time, just as they shouldn't if they're using alcohol or so forth, as long as it's not affecting, impairing them on their work and putting people at risk.
Excellent points. Thank you, Raza. Greg, I want to involve you on this one, as certainly technology touches just about every aspect of our life. Also is involved. We need there's technological solutions to assist in managing and maintaining compliance with cannabis employment laws. So, if you could tell our audience a little bit about some of those means, that'd be great.
Yep. So I think the most important is a human resources information system. So an HRS for short. That's your, excuse me, an HRS plays a critical role in managing compliance with employment law. It also creates efficiencies in back office administration by streamlining and automating many HR processes, including compliance tasks. So think of it this way: an HRS keeps you organized and acts as an electronic filing cabinet that really stores all of your employee data in a central and secure location that makes it easy to track and manage information. Some of this information can include payroll, timekeeping information, performance reviews, benefits, and perhaps some training records. You can also automate tasks such as timekeeping, PTO accruals, balance, and leave requests. That can have a big impact with compliance there, especially on the PTO accruals. My company, fortunately, we do a great job with our technology, but we've seen instances of other HR outsourcing companies that their software doesn't track that very well, and it becomes a problem when, with employees, because they want to take time off and at termination when they have to pay that PTO out. So that's huge. Compliance updates is huge as well. Greenleaf's technology platform automatically updates the technology to reflect the changes in labor law in each state. So, and I'll fall back again when I mentioned about multi-state operators and folks who have remote employees. So that's huge. I've encountered a lot of clients over the past who have multi-state operations, and they have all of their HR infrastructure in-house, and it's just maddening trying to keep up with a labor law across state lines. So our technology can really streamline that process. I think Jason and Raza were talking about employee handbooks earlier and the need for those to be updated annually. We like to do it semi-annually because labor law typically comes into effect in January and July. So when that happens, the employee handbooks will be updated, and then the employees will receive a push notification to review the updated handbook, and then they're forced to digitally sign that employee handbook that's dropped into their electronic employee file. So that's critical for compliance reasons, because if you don't have that information, it never happened. Okay. From a reporting perspective, you can't defend yourself if you don't have access to your own data. Our HRS system has more than 100 CAN reports, and we can also create customized reports through a data retriever, including 280E, which is incredibly important for our cannabis folks here. And then last but not least, data security. We every day there's a story in the paper or on the internet about companies who had a data breach. Our Greenleaf's technology platform is SOC 2 certified. And that's the highest level of accreditation there for encryption. So it's important for not only for the employer to understand or to know that their data is secure, but also from an employee perspective as well.
Understand. Quick follow-up though, how do we create efficiency while also maintaining compliance? So how do you pull that off?
Well, you think about the employee life cycle, and there's 9 areas of influence there. You start with recruiting, and start taking a look at how you're acquiring your talent. Do you use an applicant tracking service that kind of has guardrails on it to keep you compliant with compliant job applications? That doesn't have the ban the box questions, especially out here in California where it's so litigious. Other
Mhm.
states might not have those questions yet, but they're likely to follow soon. Also with job offer and declination letters that you have to send out, if you either accept a job or if you pass on a candidate. And then you can also integrate those background checks that I spoke about earlier. Then once you've selected a candidate, the real challenges begin with onboarding. Do you have up-to-date tax documents? Are you using an electronic system that automatically updates those tax documents as they come out? Each state is different. Again, with the remote employees and multi-state operators, that's very important.
Right.
Is your direct deposit information secure? It falls back on the SOC 2 certification. And then you start drifting into the HR world there. Raza referenced organizational acknowledgments. For federal and state sexual harassment, there may be mandated trainings that go along with that. You may need to get consent, or perhaps on a background check, like a semi-annual motor vehicle report for delivery exposures. You'd want to get consent for this type of stuff. And then also, have an employee handbook. We call them dynamic employee handbooks, for lack of a better term, because they're living and breathing documents that need to be updated often. And then we also have an integrated learning management system. And this is worth its weight in gold, in my opinion, because our system has over 300 different training topics, starting with mandated sexual harassment or other mandated trainings, all the way down to conflict resolution, supervisory training, to OSHA trainings. And all that stuff can be integrated into the onboarding process. And, that's really going to set the tone for your culture, setting the tone for your culture with the employee from the beginning there. Other areas of influence is timekeeping, payroll. You want to make sure that your system's set up correctly for deductions and garnishments, tax administration, workers' compensation with premium audits. The list goes on and on. We could spend hours talking about this kind of stuff. Employee benefits is always a big Achilles heel for employers. Managing that open enrollment process, making sure it's compliant in administration and reconciliation, and along with ERISA compliance and ACA compliance as well. Our technology platform can streamline and automate most of those activities there.
Fantastic. Why have you going, Greg? Can you share with our audience any costly compliance mistakes that you've seen? Perhaps folks who weren't using the systems that you're talking about.
I think meal and rest breaks that all of our panelists have talked about throughout this meeting here today are the most frequent infractions with clients that I've seen. In addition to safety, and OSHA compliance infractions as well. Okay,
understood. Real quick before I go on to our next question, I just want to remind everybody that there will be some poll questions at the end that we ask that you please answer. They're very important to us. They help us make better and more useful content for you. So please answer those poll questions. All right, next question is for you, Raza. What legal considerations should cannabis companies keep in mind when hiring employees with expertise in cannabis cultivation and production?
So we talked before about how a lot of people with experience in these areas were operating in the illicit, unregulated market. So I mean, that's one thing to keep in mind. Obviously, you want people who have expertise in these areas, but you want to make sure they're not going to carry over bad habits from their participation in the illicit market.
Right.
They're willing to, follow building codes when they're setting things up. They're willing to track and trace all the product, not be selling them on the side, and that they're generally willing to comply with the regulations, even if they were previously involved in the illicit market. They may be totally willing to comply, but you want to kind of screen on that basis. Also, when bringing people in, it's important from the beginning that they be classified right. There's different categories that workers can fall under. The first is whether they're going to be paid a salary or whether they're going to be an hourly employee. And that goes to whether they're considered exempt from the overtime laws or non-exempt. And sometimes companies will just say if someone has the word manager in their job title, that means they're exempt and they can just be worked as much as they want to, no overtime. but there's actually fairly strict standards in place. They have to actually have exercise discretion. They can't just be, in charge of following the policies with no discretion. They have to actually direct the work of other employees generally, and have some authority to hire or fire workers. If someone fits into this standard, you can generally give them a salary, and then they don't have to be paid overtime and so forth. But people get into trouble when they just slap these categories onto people without really looking at what the job role is. The other category that's important to keep in mind at the beginning is employees versus independent contractors. Employees have a lot of legal rights that independent contractors don't, including the right to overtime pay, the right to meal and rest breaks, and the right to a minimum wage. So some companies just title everyone an independent contractor to the greatest extent possible, and that can cause problems. Make sure you're looking at the actual legal standard, and that there's some justification that's documented for which way you classify someone.
So I'm an optimist, and I know we've been talking about federal legalization happening sometime. There's always, it seems like a buildup of excitement that something's going to happen on the federal level, but it falls short. But if it does happen and prohibition truly falls on, at least from a federal standpoint, what are some of the implications of that, and what do employers need to know in addressing that transition?
So the federal prohibition, that's just a really kind of unique aspect of this industry.
Right.
There's other examples where federal and state law conflict with each other, but we have such a massive commercial cannabis industry now that's legal at the state level, but not at the federal level. So it creates all sorts of interesting legal issues. I mean, the first thing to keep in mind is even with federal prohibition still in effect, the federal courts still do recognize and enforce workplace rights for employees in the cannabis industry, even though the whole industry is illegal under federal law. So make sure you're looking at complying with the federal laws, even though it's a federally illegal activity. Obviously, you cannot comply with the Federal Controlled Substances Act because selling cannabis is illegal under that, but you can still comply with other federal employment laws, and you should still focus on that. But the prohibition, it still has real effects. There's still thousands of people, as I understand, in federal prison for cannabis. Anyone involved in the adult use license industry or medical license industry still faces threats of prosecution. There's still a lot of this is done in cash only. So I think everyone's looking forward to finally when this federal prohibition ends and companies can kind of operate more out in the open. They don't have to be segregated to individual states. They can do cross-border transactions and so forth. Of course, what the federal legalization is going to look like, that's a whole other question. There's been talk about moving cannabis from Schedule 1 to Schedule 2 or Schedule 3, and that would put it in a position where under Schedule 1, there's basically not a lot of federal regulation of the industry because it's totally federally illegal. But if it goes into Schedule 2 or 3, suddenly it falls under the category of, the FDA and pharmaceutical companies, and kind of opens up a whole new world of more detailed federal regulation, pushing it into kind of the more medical and pharmaceutical framework. Also, we touched upon earlier immigration consequences. Right now, it's not advisable for anyone who's not a citizen to work in commercial cannabis because you can get deported or make it hard to get legal status. But federal legalization should open it up to having immigrants work in the industry. Also, something to keep in mind is just federal anti-discrimination laws. The states tend to have these too, but a lot of companies have DEI, diversity, equity, and inclusion policies in place to make sure their workplace is more hospitable to people from all backgrounds. You just want to make sure that you're not hiring or otherwise favoring employees based on race or other protected categories. It's great to cast a wide net in hiring, but you don't want to state that you're going to give preference to employees with any protected characteristic, because that can cause you to get in trouble under the anti-discrimination laws.
Okay, fantastic. Thank you, Roz. I appreciate that. And we're kind of short for time. I'd like to leave a little bit left for people to give us some Q&A. if possible. So, but real quick, going along to you, Beatrice, can you provide insights into the importance of accurate record keeping and documentation and cannabis employment compliance?
Excuse me. Yes, absolutely. So, again, to Jason's previous point, documentation.
Right.
We can't say that enough. You want to be, first of all, compliant with the regulations that you're documenting and recording what you're supposed to be documenting and recording. So that's really important. Make sure you're keeping detailed records about anything along those lines. Employee documentation, if there's any employee agreements, job descriptions, payroll records, tax forms, benefit enrollments, all of those to show compliance when an employee did or didn't do something you're being fair and equal treatment to all the employees. If there's any type of training or certifications, there are some regulations that may require some of your or all of your employees to get specific training. Make sure that you're keeping accurate records of that training.
Okay.
And then just auditing, making sure, as I'm sure the lawyers on the panel will attest, it's very important to audit to make sure you have those records, whether it's something specific to the cannabis industry or something that always pops in my mind when I think about audits is I-9. Go in and make sure you have an I-9 correctly filled out for every single employee that you have on your payroll. Just those are a couple of things that just come to mind as some important record keeping items.
And I would just say that record keeping, it's a particular issue in the cannabis industry specifically, just because the industry evolved and was formed under prohibition, where all cannabis activity was illegal under state and federal law. So there was kind of a culture of secrecy and avoiding law enforcement. And people knew if they kept records, those records could be used to prosecute them, to show that how much profit they were making, how many plants they were growing, et cetera. So this business kind of all developed where few records were kept, everything was in cash. Disgruntled employees wouldn't really think of suing because it would reveal their own participation in felony criminal conduct. And it was difficult to use the court system in the past, but now it's kind of whiplash where we have all these detailed regulations. The court system has opened up, and there's this kind of culture of not keeping good records that really needs to change to adapt to the new system. So this bears, it's worth emphasizing at the beginning of any business, make sure you have solid record keeping systems in place, because the culture and history of the industry are kind of all cutting against that. And it's an important area of focus.
Fantastic. Anybody else want to add anything about the record keeping? Did you want to jump on that?
Well, real quick, don't keep too many things though. Make sure it's the right stuff. Because the reason why I say that is sometimes you'll have a leader put in an email, which they shouldn't put in email, certain verbiage and things, and then it gets saved in the employee's file, which just make sure you understand what the compliance areas require you to keep as it relates to documentation. It's a good thing, because I do think, Roz, on the flip side, I've gone and done many audits, and there's too many things in the employee file that don't belong. So it's making sure that you understand what's truly needed and required, and following those standards.
And I think advising your employees what to put in writing versus sensitive conversations that
Absolutely.
Person or over the phone. You should always, when you send any email, you should always imagine that it's going to be an exhibit, an obligation, and just think twice before you hit that send button.
No doubt. Yeah. Imagine a federal judge reading the email, and how would you send it? So, we have two questions that have come in on the Q&A, and I want to throw the first one. Actually, this one's going to you, Beatrice. Outside of the handbooks and training, how would you navigate management being baited by employees?
Ooh, that's tough, because that can really happen in any industry.
Oh yeah.
And Jason, please feel free to jump in as well. But I think the main thing is you just go back, you point back to the handbook and the trainings, and you point back to what your policies are, and you just become a broken record. Right. You just say it over and over again, like, here's the policy, here's what we have in writing, here's what we have documented, here's what you agreed to abide by when you signed off on the handbook. Hopefully they're signing off on the handbook, all of those things, and you just be that broken record.
Yeah, I would second that, and just make it required that people sign the handbook. Otherwise they can't work there. Just that simple.
one more question here, and I think we have a little bit more time. So if anybody wants to get in on the Q&A, please send us a question. Okay, since cannabis is illegal federally, how does it work if you are audited by the IRS? Could a federal judge shut you down?
I'm not.
That's Raza. That's
Well,
Raza.
Theoretically, a federal judge could shut you down. The whole recreational cannabis industry violates federal law, and there's something called the Rohrabacher-Farr Amendment that prohibits the federal government from going after certain medical cannabis businesses, but there's no similar legal protection against federal prosecution. So there, to a certain extent, everyone in this industry is operating just on faith that they're not going to be federally prosecuted. But, I would say that, complying to the greatest extent possible with federal laws, including federal tax laws and IRS Section 280E, it's important, to cooperate in any federal audit. It's just, it's a tough place where there is a possibility you could be shut down, yes, but complying to the greatest extent possible with federal laws is the best way to ensure that you're not going to be targeted.
That's why you're watching this webinar today. Learning about compliance, right? It comes full circle. And one more question on the Q&As. Any thoughts on the Taya Olenowski case in New Jersey and Wires Drays? I don't, this one is new to me, so I'm not familiar. Anybody under the Olenowski case in New Jersey? Maybe we have some time to Google that. We could get you somewhat of a response. Maybe we have a follow-up on an email.
Yeah, there's another one question there. It looks like Jim that just came in.
Yeah. Okay. What are the biggest challenges for mid-managers in the industry?
I'll give it a go.
Okay.
It's knowledge and training. I think too often these a lot of companies start fast, right? They want to start fast right away, but they're not getting the proper training. So they're making very minor and simple mistakes when it comes to their talent and managing of people. So this is where, I think all the products that are offered, through Greg and Beatrice are really the best way to go, because then you have all the compliance training in there, but you also have the management training, crucial conversations, how to basically, work with people, how to give performance, evaluations, give difficult discussions, things like that. So I really think it's training. I can't stress it enough for these mid-level managers. And it's probably not only their first job in a professional setting if they come from the illicit market, but it's their first management job.
That's
which
right.
If you call your first management job, I know I wasn't that great, but I had good mentors that would help me along the way that I could go through.
Fantastic. And one more question that came through. It's kind of a race here. And this comes from one of our attendees. We are medical providers who still have work from home providers. Do we need workers' comp insurance? OSHA for work from home, finding a program for medical providers that is cannabis friendly. Some of our programs have locked us out from texting patients because we use the word cannabis. Any thoughts?
From a workers' comp perspective, if you're a remote employee, that is considered a work site location. So you are required, the employer is required to provide workers' compensation insurance.
No doubt. Maybe we have a follow-up on that, and please, because we're about out of time. So we're going to bring the webinar to a close. Thank you, everybody who attended, and we appreciate it. Please feel free to send us emails. You should be able to get our information pretty easily in our communications, and we plan on having more of these. So we welcome you to attend again, and send us suggestions on what you'd like to hear in terms of content. We want to provide useful information to our community. So with that, I'll bring this webinar to a close, and thank you to our panelists. Excellent job, and lots of very useful information.